Hello and welcome to this ASEDS webinar, Bridging the Gap Between Legal and IT, Working Together in eDiscovery, presented by ZyLAB. I'm your host, Robert Hilson of aseds.org, and today we have a great presentation for you, but first I have a couple of quick announcements. For those of you who aren't familiar with us, we are a members-only association that provides training, resources, and networking to the eDiscovery community. We also offer the Certified eDiscovery Specialist credential, which is held by hundreds of professionals across the Americas, Europe, and Asia. You can join today and start receiving a number of benefits exclusive to our members, including news content, on-demand web seminars, our Bits and Bytes newsletter, and discounts on certification and next year's conference. The seminar today will be permanently hosted on our site and available on demand along with many others. They offer practical training and knowledge from top practitioners around the globe, and they are available to you right now if you are an ASEDS member. So for more information about membership or to sign up for certification, go to aseds.org/join. All right, now I'm pleased to introduce our three great speakers. First, we have Chris Dale, who is owner of the eDisclosure Information Management Project, which disseminates information about legal technology and disclosure issues in the United Kingdom. He was a litigation partner in London and then a litigation software developer and litigation support consultant before turning to commentary on eDisclosure and eDiscovery. He is a member of Senior Master Whitaker's Working Party, which drafted the new eDisclosure Practice Direction and Electronic Documents Questionnaire. Chris also writes the UK's only authoritative and objective website and blog on the subject and is a well-known speaker and commentator in the UK, the US, and other common law jurisdictions. Chris, thanks for joining us.
My pleasure.
Chris is joined by Dr. Johannes Scholtes, who has been on these webinars before. He is Chairman and Chief Strategy Officer of ZyLAB. As the company's president and CEO from 1989 to 2009, he shaped ZyLAB into an information management powerhouse in countries across the globe. His leadership and vision led to ZyLAB's selection for high-profile engagements, including the U.S. War Crime Tribunals, FBI Enron investigations, and the United States White House Executive Office of the President. Jan, thanks for joining us.
Thank you.
And last but not least, we have Mary Mack, who will be our moderator today. Enterprise Technology Counsel at ZyLAB. She is an attorney and strategic advisor for some of the largest products, liabilities, class actions, internal and government investigations, and antitrust and IP disputes. Mary's clients include the largest law firms, pharmaceutical companies, and insurance companies in the world. She is a member of the Illinois Bar and the ABA's section on litigation. She is also the co-author of the popular book, A Process of Illumination, The Practical Guide to Electronic Discovery, and eDiscovery for Corporate Counsel, published by Thomson Reuters West. Okay, again, thank you all for joining us. A reminder to our audience, if you have any questions for the speakers, type them into the chat box that you see on the right of your screen, and we will address them at the end of the presentation if time allows. Okay, Mary, I'll hand it off to you.
All right, well, thanks, Rob. Today's agenda, we're going to be talking about something that I think we've been seeing in the legal tweets, certainly the disruptive nature of eDiscovery and technology, the different roles, the different players in this ecosystem, and the conflicts of interest, both legal and business and practical, and then some of the more successful models the organizations work towards, and how legal and technical professionals can move from reactive to proactive. The ideas here, of course, are not legal advice, but rather educational information. So everybody's got a particular situation and should consult the appropriate professionals. And Gartner says that most organizations are ill-prepared for litigation because their records management policies and eDiscovery processes are misaligned, and that IT professionals need to prepare for the special demands created by eDiscovery. Now, Chris, this is not new, and what is it that you're seeing that's such an issue with IT and legal and records management aligning?
Thank you, Mary. This word disruptive is an interesting one. It gets thrown about a bit like lots of other terms in this area. What it really means is it destroys everybody's peace and quiet, I think, in this context. Records managers like to get on quietly managing records, and then along come eDiscovery demands. Why should anybody care? Going back to the Gartner point about records, policies, and eDiscovery processes being misaligned. Why should anybody care about eDiscovery processes? Well, the obvious answers, the ones always given, are that there's risk and there's expense. There's risk expressed as fear of sanctions, because you haven't given discovery of the things you should have done in civil proceedings or to a regulator, fear about losing reputation and so on. And there's also considerable expense incurred that isn't necessarily budgeted for. That's all important, but I prefer to think of slightly more positive things, the risk that you can't find the evidence that you need to win a claim or to beat off a claim. Not so much the purely formal, have I proceeded with the procedures, but can I actually find the stuff I want, which tends to be overlooked in a lot of talk about eDiscovery processes, never mind records management. Companies are bothered about, or at least courts and regulators are bothered about, the speed of recovery. How quickly can you deliver on the obligations? There's more to it than that, I think, and more to it also than just expense. Your whole strategy and tactics in dealing with other parties, in dealing with the courts, in dealing with the regulator, may depend on finding the right stuff quickly and making decisions about it. When you come to look at the cost, it's tempting, and a lot of companies do this, they just think of the server costs and the men in white coats who look after it and the heating and the lighting and so on. And they look at that and they say, well, that's not very much, we can cope with that as a cost. It'd be nice to get rid of it or reduce it, but it's not a major thing. What that overlooks, I think, is the eDiscovery costs that hang contingently over most companies. The costs of collecting, the cost of searching, the cost of processing and analysis, and before all that, the legal hold. And the lawyer time that's spent going through all this stuff, and often over the same material over and over again in order to discard it. If the same processes are run multiple times over the same data that was never worth keeping in the first place, that's an awful lot of money going down the drain. And questions ought to be being asked by internal lawyers. Why are you reviewing this stuff for discovery? If we're reviewing this stuff for discovery, why not ask the question, do we need this stuff at all? If we don't need it for this case, do we need it for any other? Is there a benefit to the company? Is there an obligation, a tax obligation or a corporate obligation, or perhaps just as importantly, does it have value for the company? The idea of throwing stuff away in this way, even if that word defensible is put in front of it, runs sort of counter to the principles of most IT people. Their job is to keep stuff safe, and if they run out of space, they buy another server. And the idea that one gets rid of stuff is not necessarily an appealing one. Similarly, the lawyers are guided by safety. It's much easier to say, let's just keep it. And to that extent, there's actually an alignment between lawyer and IT people. Our general line here is that there's conflict and gaps between them. But when it comes to decisions to keep, quite often we find that they have the same point of view. Clients should really be asking, why? What for? What is this risk that you're telling me about, so that I can set it against the costs of keeping it all? Which opens this point I raised before about sharing the investment. When money is having to be spent on discovery, why not use part of that money to fund a deletion exercise? And as I say, asking this question, will we ever need it? The real problem, I think, is that many companies simply don't have a means of tracking the cost. They don't actually know what they're spending, and one hears the general anecdotal idea is that general counsel are terribly concerned about what's being spent, which then runs into survey results which show that many of them don't actually know what they are spending and what they're spending it on. That, I have to say, is changing. We're beginning to find a closer focus on that, closer pressing of external lawyers to say where the money's going, and the appointment of new people whose role it is to sit over all these aspects of it. We'll perhaps come on to that in a minute. But we're left, I think, with the idea that IT and records management people don't really understand what it is that the litigation lawyers need and what they're going through. And in turn, we find lawyers taking the records managers for granted. They treat them often perhaps as a resource they call on urgently when a problem arises. And what's needed, I think, is a better keeping of the aggregated costs and breaking them down. We are, as I say, seeing changes. We're seeing focus beyond things on just bandwidth and security and server space. We're finding IT confronted by privacy and data protection issues, for example, which turn up a lot in eDiscovery, have a lot in common in the sense that the ability to search and tag and identify things that have particular characteristics arises in relation to privacy and data protection, just as it does in Discovery, and Discovery gives us a closer focus on it. We're seeing, and it's a good thing, I think, a new breed of people, and people who've crossed borders, people who started as lawyers and who are going across into information, and vice versa, people who have a skill that a company values, who are being given legal training. That, I have to say, is anecdotal. I don't know that there's any statistics to back that, but that's the impression I get. And that may help over a period to close the gap between the players who are shown on the slide here, the IT department, security and HR, and legal departments. Before you can understand a gap, you have to recognize that there is one, and we're perhaps beginning to see that. At a simple level, why don't you talk to each other, is one suggestion, even at an informal level, and find out what the problems are. We have privacy, we have social media, we have all sorts of things that require policies, and those policies have a direct impact on what comes up as an issue when eDiscovery arises. A clear situation where everybody needs to know what the risks, what the costs, what the pressures, and what the solutions are. Summarizing all that, really, if the finance director or whoever's in control of the whole picture was able to see everything in one place, then it would be easier to establish a return on investment for this bridging of the gap, for this bringing of people together, for this developing of a common perceived interest, and the calculation of risk against cost would become more clear. On all that, ignores what's perhaps the most significant thing here, which has nothing to do with eDiscovery at all, which is that if you do get rid of stuff, if you do have a closer focus on what you are likely to need, that can extend to the things you need for the business, things that have hidden value in the business, which could be used to promote the business itself. If we move on to the next slide, that shows us the EDRM, the standard picture of the processes within a litigation or other dispute, from information management on the left-hand end. And when the EDRM was new, it was enough, I think, everybody was busy focusing on the bits in the middle, and it was enough simply to relegate information management to a single box over on the left-hand side. We're seeing that changing. We're seeing that being identified as the most important place, and not necessarily a place where you find the lawyers. And the next slide shows us the development by the same people who gave us the EDRM, the information governance reference model, with all the elements within a business, the business units at the top, the people who actually generate this data and who need it, the IT people going around to the right, whose job it is to look after it and secure it, those who are concerned with legal risk and with the whole sort of business of managing risk, all have a community of interest. One of the most interesting things, I think, for external lawyers at the moment is to begin to think that there's work for them that they've never fully exploited in advising their clients about preemptive things. If we move on to the next slide, Lawyers, external lawyers tend to get involved on the reactive stuff. There's a trigger, a regulatory demand, some proceedings, need for an investigation. And everybody rushes around madly, including people who might have been speaking to each other, should have been speaking to each other in the past, but actually come across each other for the first time when some crisis brings them together. You get substantial expense, expense which has not necessarily been budgeted for, and expense which might be seen as the lawyers doing a company's information management for them in a hurry at external lawyers' rates. No option, got to be done. And with that one sees an assessment of the risk, perhaps made in something of a hurry, but weighing the cost against the potential downsides, and perhaps having to say, well, we're going to have to take that risk, or we're going to have to spend whatever it takes to buy us out of that risk. Rather better, if you look over on the second side, the proactive side, to think not of triggers, dealing with things as they arise, but anticipating contingencies, managing risks, having policies in place, developing processes so that you know what will happen in any particular event. And to do that properly, to do that adequately, one needs an interplay between those who are customarily on the reactive side, the ones who deal with the problems when they arise, and those who control the data, control the servers, and are in a position to develop the policies. It would be good to see, and we are seeing, I think, a closer connection between those two groups of people.
Chris? Chris, how you mentioned that one of the issues is that there's a shared accountability for this function, things like data disposition and information governance and the like. How are you seeing organizations be successful in moving things forward? Do they appoint one or the other? Do they have a shared governing board? Who are you seeing beginning to charter those projects?
Well, it would be good to think that there is a sense of a shared responsibility, and obviously in many companies there are. I think the gist of what I said earlier is that in too many companies it's a distributed responsibility. We depend, as I said, Mary, on anecdote. I can't put my hand on my heart and say I can point to 25 examples of big-name companies or representative companies who are doing one thing or the other. One relies on the feedback that one gets, what one hears out in the market, as it were. It's very generalized. I'd love to be able, as I say, to point to specific examples, because if we could find them, we'd have them out in conferences and on these webinars to tell us of their experiences and what the benefits are. So I don't, alas, have statistics beyond the anecdotal material that I've referred to.
Oh, very good, very good. So,
well,
Jan,
it would be better. Sorry, Mary, it would be better if one had
okay.
The statistics, but it's hard to persuade the people to come out and tell us what they've done right, because that almost inevitably involves explaining what they've been doing wrong.
Exactly, and in my experience, many times organizations will not want to put their secret sauce out there, lest they set a bar too high for themselves for litigation down the road as well. So I think the anecdotal, or the as we move forward, maybe some of the surveys will get underneath that with some anonymous data, and I think that will help us quite a bit into moving the as you put it, the distributed responsibility into more of a shared accountability.
Yes.
So, Jan, we've been talking about some of the more softer organizational communication issues, and a little more of the harder stuff about valuing. What about the technology piece of being able to address some of these proactive, very long-term projects in the context of sometimes a pretty rocky road of litigation?
Yeah, yeah. No, and that's a very good question to start with, because what we see happening in this market is that more and more organizations are now proactively looking at addressing the risks and the cost of e-discovery. And what we see is that before companies are really willing to do so, they must first go to some painful e-discovery projects. We see that unless organizations have experienced how risky e-discovery is, what regulatory investigations can do not only to your company, your productivity, but also to your reputation in the market, they are not really willing to invest in being proactive. Having said that, of course, in the United States, many companies have suffered from civil litigation and regulatory investigations over the last couple of years. And we see that almost all of our clients who have brought e-discovery in-house, who've taken control over their e-discovery data, the next step for them really is to be more proactive. And what we see happening is that some of these organizations, they even created new job titles for it. And I've seen job titles in financial companies like Vice President of Data Risk Assessment. I've seen job titles like in a large international chemical company, Vice President of Legacy Systems. And Gartner is talking about a new role which they call the Chief Data Officer. And I think what's the most important to understand from those observations is that if you look at the data, a lot of data, or almost all of the data in these companies and organizations is owned by the business, and the business wants to keep the data forever. Legal wants to dispose data as soon as it's legally allowed. IT primarily concerns about bandwidth, storage, and they don't necessarily look into the content of data. And there's this whole new breach of job titles like data protection officer, compliance officer, risk officer, auditors, people that are aware of the risks of data and that want to do things. But what we see happening in these organizations is that unless everybody cooperates and unless everybody's on board, and also unless there is support from the top, these projects will not really take off. You really need to have support from the top, because otherwise people will constantly say, well, it's not my budget, you have to pay for it, and point to each other. Or they hide behind the first objection, either technical or legal, and say, well, you see, this is what I expected, we cannot move forward, so let's just leave everything as it is, and just hope and presume and pray that there will be no short-term litigation. With ZyLAB, with our technology, we've always been playing in both of these fields. So we've been using technology to make litigation response as easy as possible and do everything that you just saw in the eDiscovery EDRM model, from identification to preservation, collection, processing, which are really typical, the left side of the EDRM components that have been brought in-house for a long time. But what we see happening in the last couple of I would say 18 months is also that organizations have taken control over their data in the review process. So instead of handing all their data over to third parties, they either host it from within their firewalls, or they organize some kind of private cloud somewhere. They buy software and they host the software for all of the external parties that need to look at the data, and they keep complete control over their data. They can do early case assessment themselves in parallel. They can try to settle a case on favorable terms. And even the production has been done in-house by these type of companies. Now, what we see happening is that once these organizations have gained an understanding of how to process and manage data in a legal eDiscovery, they, at a certain moment, because they don't have eDiscoveries all the time, there are certain moments where the people that are trained in-house, are educated, can also start using the same technology to be a little bit more proactive. So what they can start doing, they can start collecting data from risky places and see if there is any compliance risk, any risk related to maybe bribery, fraud, export controls, whatever. And that's also when certain, the better companies start using this technology to implement records management activities. And then instead of doing it when the document is created, which was the best practice records management policy in the past, you create a document, you say, okay, here it goes into the filing plan. This is the retention period we expect, and then it needs to be transferred, destroyed, or retained, or whatever. Now we see people create data all over the place, and then a certain moment said, oops, we have these terabytes of data. Oops, some of it is 15 years old. Why do we still have it? And what you can do with technology such as ours is that you can do records management after the fact. And you can start collecting data, processing it, analyzing it, tagging it, reviewing it, do quality control. You can do it very, very efficiently, and then really use the same techniques and the same tools as an eDiscovery, but you just use them in a more readiness, in a more proactive approach, and it's the same tools just configured a little bit differently. And instead of generating legal productions, you generate reports where you indicate you have an overview of where your potential risks are, and what data you have, and how old it is, and what type of data it is, and which projects it relates to. And what I can show you a couple of examples in the next couple of slides. But first we have to go to the next slide. And this is also what Chris said. What's very important in the legal space is that whatever you do, whether it's eDiscovery or whether it's defensible disposition or it's analysis of data, whatever you do, it has to be defensible. You must have a defensible, repeatable methodology, which is transparent, which is clear. And this is one of the things we've been doing with our software for a long time. We've always supplied our software together with a methodology, a template set, a framework that allows our users to keep track of everything what's happening, build a full chain of custody, and whatever decision they take and whatever they do, make it defensible. Now let's go to the hardcore software, and if you take me to the next slide, Mary. Yeah, thank you very much. One too far. There we go. Yep. So this is the first part, starting to collect data, not only from your internal systems, but also from your social media for cloud or Microsoft 365. And you see a couple of examples here. And this is very important because our data is no longer completely under our control within our firewalls and our safe corporate environments. More and more data is outside of our control. And so first what you need is technology to collect this type of data in a smart way and also from as many repositories as possible. Now that's exactly what we do. If you look at the next slide. With ZyLAB we've really focused on, and we still see that this is a major requirement from all of our clients, supporting as many file formats, database repository connectors and languages. At this moment we support about 1,000 file formats, around 200 connectors to a variety of different systems, and you see a couple of them listed there, anything from ECM systems to ERP systems to databases to email to Microsoft SharePoint file sharers, all kinds of systems, but also as many languages. We live in a global world, and more data is available in non-English language, and we support all of that. If we go to the next slide, this is also one of the reasons why we have integrated machine translation, and this allows you, as you can see here on the right, a Russian document. On the left side you see a machine translation of that document, which is not a legally submissible translation, but it gives you a good idea about the content of the document. And then if you need to submit it in court or for the case, you can always have a professional either clean up this machine translation or make a manual translation, which is defensible. Now the next phase after processing, which I won't go into right now, is because that's something we do fully automatically out of the box, and we can analyze data, is going to the review. And if you take me to the next slide, Mary. What we've done with our review technology is to focus on simplicity. If you want to bring review in-house and you want to review maybe a couple of cases, smaller cases yourself, because that's what we see a lot with civil procedures. Many cases consist of small cases. Every organization has a number of large, complex cases you want to outsource. But there's also maybe these like many little HR cases or other cases that you know how to do it. You've done a dozen of these type of cases in the past, and why not do them in-house? And this is what we've created with our legal review tool, Simplicity. So it's a very easy environment to review your documents, or have your external counsel or maybe forensic accountant log into your system and have them review a subset with particular documents that require certain legal skills that you do not have in-house. You can browse documents, search them with our state-of-the-art top search technology, produce documents, and it's full enterprise software. So it fits in your environment. It has all security roles and all kind of other functionality you would expect in an enterprise software product. Now, if you take me to the next slide, this is where it's getting interesting. One of the things we can do is we can automatically tag documents, call it technology assisted review, by using different rules and different reasons why something is privileged or confidential or responsive. And what we use this color coding, and this color coding is very powerful. It's very efficient. It's users can immediately see, okay, what's the tagging, and we also use intelligent tagging. So if you have assigned a certain type of text, there's logic which does not allow you to assign another type of tag. You can define all of this hierarchy of tagging yourself. You can define valid combinations, but you can also integrate with APIs to for instance, a CRM system to use that for privilege tagging. You go to the next slide. There's another example. We can bring in-house legal production. This used to be something that could only be done by highly specialized service bureaus. We've had so many clients that needed this functionality over the years. What we did is we decided to build a version and take that could be able to be used in-house. So we took all these requirements, all this functionality, anything from burning in redactions to bait stamping to all the strange requirements that we've seen over the years in legal productions, and allow organizations to do legal productions either TIFF or PDF or natively, or combinations or hybrids with or without placeholders and exceptions and everything into an in-house solution, which is not only very fast but it's also very stable, and it's a great tool for organizations to bring this expensive part of the process in-house and keep the cost down. Now, once they've done this, let's go to the next slide, because this is where I think the most interesting development is that we've seen recently. What we see happening is that these organizations that now have the skills in-house and have people that are able to process these data collections, and now there's no reason why these organizations do not want to be proactive, because they have the tools, they've spent the money, they've trained the people, and if there's some time, and you can even use this as like a formal training of new employees in your litigation support department, they can start what we call big data risk management. Every organization has big data these days, but there's risks to these big data collections. We also call that the dark side of big data, and you should definitely download our white paper that describes a number of great cases and statistics from that point of view. Now, some of the risks you see are security risks. This is something IT is always interested in. Which documents have been misfiled? Which documents have access rights on the network, which are wrong, and which could lead to either intellectual property theft or data leakage, and of course fines, sanctions, lawsuits, everything. What are other data protection and privacy risks? It could very well be that your organization still has data which is 10, 20 years old. Maybe you need to keep it, or maybe it's 10 years old or 7 years old, and this data contains personal identifiable information which may not have been illegal 7 years ago or 5 years ago, but now, because of whatever new Privacy or Data Protection Act, it suddenly is illegal. And then you want to know about the data. You want to clean it up, and you want computers to automatically detect these type of risks, and that's what we can do. Same with bribery and fraud risks. Same with export competition and non-compliance risks, etc. And the goals are really, first of all, understand what you have, understand what data you have and what is in that data. Second, defending your data, your organization against the dark side of big data. And that can be anything from doing defensible disposition to reporting to solving problems, or taking proactive or premature actions if you run into certain things that are not right and you need to take action. And a couple of other examples on the next slides, just to make it a little bit more concrete, is, for instance, this is a couple of patterns and rules that can be used to find documents violating privacy acts and data protection acts. And you can see there's many languages there, but there's also examples of work product privileged, attorney-client privileged, physician-patient privileged, etc., etc. And we have many of these type of patterns in many languages for all the problems that I just addressed, for bribery related to FCPA, for privacy violations. On the next slide, there's a couple of examples of bribery, like certain patterns that we can define in a very easy way that allows you to do semantic searches of finding linguistic patterns where a person is offered or receives or a trip or a meeting in a certain country. And then we define these patterns very simple on the left-hand side, and we have a graphical interface to do that and can do some linguistic things there. But then it finds these great sentences on the right. Will you please to offer you a complimentary trip to Thailand? Will you join us for the sailing trip to Spain? These may be very interesting emails if they're sent to your purchase manager or to somebody else who's a big fan of a certain product, and you never understood why they're supporting that product, and then you find out that they're receiving all kind of non-documented gifts from the supplier. Same with people, receiving something from other people, people replacing, old contracts with new contracts, finding networks with family and other, non-business relationships suddenly being active or found in a business environment. So these are just a couple of these examples. And the last example on the next slide is, for instance, the defensible disposition, the legacy data cleanup. When you do a data migration or and we'll tell you a little bit more about that later, what you can do is you can analyze the data, and we can try to map as much data as possible into where it fits in your filing plan. And then what you get is these type of reports, which gives you the insanity of data, or it shows you where the data is from. This is my filing plan, and then based on all this information, you can take actions like, okay, I want to destroy it, I want to keep it, I want to transfer it, I want to redact it. And then you put it into managed archives where data is like automatically destroyed or retained or transferred by your rules. So this is what we call like records management after the fact, where you're going to clean up your large collections of unstructured data at a certain moment in order to prevent them from becoming problematic. Now, if you got the next slide, when is a good moment to do this? Because you have to build a business case, and your boss or your CEO or CFO is going to ask you, oh, well, why do we have to spend all this money? Let's just, we don't have a lawsuit. We're a good company. We're never going to get a lawsuit. And so why do you want me to spend money here? Now, what we see is that there's a number of good moments to start talking about this. And that's when data is being moved anyway. And we see that in the case of a data center or server consolidation or server virtualization into virtual machines, or when there's a cloud migration, or when you have data from a company which has been acquired. You buy a company, you buy all the computers, you buy the software, people leave, and then you're stuck with tons of data. You don't know what's in there. Or when you close down an operation, that's a good moment. When you want to do software maintenance consolidation, a lot of these projects can be funded by no longer paying software maintenance, especially legacy systems, old legacy systems, and think about Lotus Notes and a couple of other systems in the market. Companies still pay a lot of maintenance. You can often fund these type of projects from no longer paying the maintenance. Or when your organization has litigation, the whole company's been disrupted. Your management has been working overtime, 20 weekends in a row, no family time, no holidays, no vacation. That's also a good moment to start talking about this post-litigation or investigation. But in all cases, IT and legal have to work together, and there must be support from the top, otherwise this is not going to fly.
Can I put in a plea there, this is Christine again, for a reminder of something I said earlier. Post-litigation certainly is a good time to start looking. Doing it, as I suggested earlier, whilst you're actually engaged in the litigation, whilst there's a budget actually available for the sort of searches, the sort of investigations that Jan has been talking about, as opposed to necessarily leaving it at the end when everybody's had enough of the subject and had enough of the lawyer's bills and only too glad to shut it back in the drawer again. There is a lot to be said for tying up the defensible deletion stage, that investigation stage, with the work that has to be done anyway for the litigation or for the investigation. Can I just add another point derived from what Jan has just said? The searching for example, to anticipate bribery or anti-competitive behavior or whatever, may itself walk into privacy problems. Certainly in the EU, problems can arise in relation to the rights of the data subject if you start tracking what they're doing in anticipation of the possibility that they might be committing some sort of act, of illegal act. All that is an argument for controlling your personal information as you create it, if you possibly can, so that it's flagged from the beginning, so that you don't have to do the sheep and goat separation in the course either of a preemptive investigation or, even worse, in a hurry, in an action investigation.
Yeah, absolutely, and it's a very good remark, Chris, there about privacy, and everybody knows that in Europe there's a lot of issues about privacy. Now, having said that, it's very interesting to see that in Europe we talk the talk, but in the United States, they walk the walk, because that's where the biggest fines are being given for companies violating privacy regulations, where I think in Europe the fines are still pretty small. They're talking about increasing it, but it hasn't been approved yet. But what we see in like even in countries like Germany and France, if you do have a healthy suspicion and you do suspect that something is wrong, in those cases you have to say what you're going to do, why you're going to do it, when you're going to do it, and how you're going to do it, and then you can more or less do whatever you want. But just looking at data without any indication of or any suspicion, no, that's not the recommended way of operating. I think not only in Europe, but also not in the US.
The whole issue of consent drops away if you get rid of stuff at the time when you're supposed to get rid of it, which is usually when on the expiry of the purpose for which it's collected, which is something that the EU Commission is actually looking at.
No, absolutely. And what we've seen in the case of the Enron investigation is it's a very, very bad practice to remind people of the retention policy when you're in the middle of litigation, and that's too late. And I think there was another case recently, Mary, where a company also, was it the IP litigation case, where a company started?
Oh yeah, that was the Rambus case.
Oh yeah, that was the one.
Yeah, where there was basically the destruction was in anticipation of litigation instead of preservation. It was more of a preemptive destruction according to the court.
No, and that's too late. Yeah.
So nothing to do with defensible deletion at all. It should be clear that those of us who are urging deletion do mean only those things for which there is either no current legal hold or for which there is no current business use.
No, you do the right things, but you did them at the wrong time. I think that's...
Yes, I think
current or reasonably anticipated legal hold, I should say. Sorry.
So, Chris, you mentioned something very interesting, that in the middle of a litigation, while there is a litigation budget and there's outside counsel oversight, that might be a time to address some defensible deletion, and that's very intriguing to me, because certainly in the early case assessment world you can sort into responsive, non-responsive. You've got your privacy protocols put together, but as you said, there may be other legal holds. And so, are you suggesting that perhaps outside counsel might propose a project that would also look at the other outside holds and be able to parse that more non-responsive data for deletion. Is that where you're going with this?
Well, yes. Clearly, one can't turn a discovery exercise is big enough in its own right, and to suggest that you want to turn it into 10 times that for other reasons isn't necessarily going to go down well. I wasn't necessarily suggesting that one should investigate, begin by saying what's under legal hold. I was rather more suggesting one does it the other way around. We have looked at this load of documents. We have decided they are of no value for this litigation. They are not potentially discoverable. While we're at it, are they potentially discoverable for anything else? Well, the first question is, are they in fact subject to a hold? And one would hope that companies who are serious about this will have some means of identifying and probably locking anyway documents that are subject to a hold. Assume the answer to that is no. What else do we consider? Well, is it required for some tax purpose? Is it required for some corporate purpose? Is it actually interesting to anybody? It's a great deal easier, clearly, if your system, whatever it may be, includes the ability to flag anything that is currently subject to a hold, because which, as I say, one would hope many companies would have by default anyway, because clearly there's no question of well, you might question whether the hold is still a current one, I guess, but it's really, I suppose, the beginning of what I'm suggesting is that whilst you're asking questions about a batch of documents, which may be a single document, maybe tens of thousands of documents, and whilst you've got some brains focused on it and some budget, it is worth thinking rather more widely than the simple question, is it relevant in this pending litigation? And what one perceives, and again this is more a matter of anecdote than statistics, is that companies are going through the early stages of discovery, the preservation, the collection, the hold, over and over again in relation to the same documents and rejecting them every time, perhaps, without having any means of recording the fact that this batch of documents has come up 10 times in the last year and never been used once, for example.
Right, or it's plain old junk.
Or it's plain old junk, but I'm trying to be sort of slightly more sort of metrics based on this. If one had some means of recording the fact that a document has been considered for discovery and rejected, and to accumulate that, so in other words, it has been considered and rejected 10 times in 2 years, or whatever the threshold is, which ought not to be beyond the wit of those who manage big data, then it should be relatively easy to park those into a, not necessarily delete them, but to park them somewhere out of the main area for somebody to consider the question, if we've rejected them 10 times, are we ever going to ask for them? Are we ever going to need them? Given, for example, that in most companies the same custodians come around again and again, generally a relatively small subset of people whose documents are needed repeatedly. It's not that there's a simple answer, and it would be foolish to say there's one simple solution for any of this. But I do see some sense in the idea of asking the question, whilst we're doing this, can we also do that?
Well, and one of the big benefits of bringing that part of eDiscovery in-house and controlling not only your data and your processing, but of course then you also control statistics about data and about particular files. And the whole issue about eDiscovery is that when in the identification phase you have all these unstructured collections of data, which create a problem. But if you would organize your data in more like controlled archives, or at a certain moment after you're done creating all your archives, once so many times put it into like, okay, this is related to this project, this is attorney-client privilege, this is related to this project and this and this and this, then not all of your documents will be discoverable, because from the start of the identification you can say, well, the documents that I've stored here by definitions are not discoverable, or they're not subject, or they're related to something completely different. And then you make the whole review process much easier, because a lot of the cost of the review process has to deal with the fact that documents are all, dumped in a big, location where there's a lot of data, and it's all intermixed, everything. And by regularly cleaning up your data sets, you make it much easier to identify what is responsible for a particular case and what's not.
The attraction of this route is that it doesn't necessarily involve more work with each batch of documents. What it does require is some means of retaining information which is automatically generated as a result of some prior decision, accumulating it and having it available for use for subsequent decisions, not just reusing for the next discovery exercise, but potentially dropping it out of all future discovery exercises because of what you've automatically stored about it in the past.
Okay.
So very good. So we can see that we have a good reason to do all of this, especially with the new regulations. And I mean, every day there's a new app or a new social media thing. I just saw, Jan, we'll have to pay attention to this as well for Office 365, that they are going to two-factor authentication. So there are so many changes that are coming rapidly in technology, as well as in the law. We're seeing what's happening over in your neck of the woods, Chris, with the new civil procedure that's coming up.
Shall I just say briefly about that while we're on the subject? That the changes that have just taken effect in relation to civil proceedings, loosely called the Jackson reforms, include amongst their requirements that parties are able to identify their potential sources of disclosable information and to be able to assess the costs of giving disclosure of them. With an express focus on proportionality, and to do so pretty early on in the proceedings, before the first case management conference. If you start from the position that you know nothing about your document population, then you really are in the position where you're having your lawyers undertake your information management at their rates, as I put it earlier. You're not only spending a lot of money you might otherwise not have to spend, but you're also losing a tactical advantage vis-a-vis opponents who very easily see that you're on your back foot there. So that's all boiled down very simply to, you need to know early, for the purposes of the rules, what it is you've got and what decisions you're likely to make about it. That's actually a reflection of what companies, as it were, ought to want to know anyway, not just because the rules require. The idea that you have a handle on what it is you've got and what the expenses are and what alternative ways there are of dealing with it is not a bad one. While I'm on this, there's one element effectively missing from the conclusion, the bullets on this slide, and that is that the costs available, the budget available to General Counsel are going down. So there are bigger risks, bigger problems, bigger volumes, at the same time as the funds available to deal with it all are reduced, and that leads eventually through to the idea that we've got to find different and better ways of managing what we've got in a way that doesn't cost us a fortune, or specifically saves us from repeating the same exercises over and over again.
Very good, Chris. Thanks for giving us that that in-the-minute update too about the Jackson reforms. We're opening up for questions.
Yeah, Mary, we have a few of them. So if you don't mind sticking around for maybe 2 or 3 minutes over, I'll just rattle them off. And Chris, the first one's for you. You mentioned how IT and legal have kind of this common culture of anti-risk, and they're both kind of generally adverse to disposing of data. And I'd add to that, too, that I think record managers generally feel like they're being kind of kept from the decision-making process. So if all that is true, where does this kind of drive within a company come from to start implementing some of these defensible deletion procedures?
Well, Jan put it in sort of very broad terms, from above. Clearly somebody who has a role that's greater than the roles, or with more influence and power than the roles of the individuals responsible for the separate budgets, has got to make this decision. What I think we're beginning to see is more roles created with the word information in their title. Indeed, during last year in the US, we started seeing more senior positions created with the word discovery in their title within corporations. which is, in other words, giving a bigger voice within the company to those who are going to have to sweep up the problems when they arise. It's hard, you can't be specific about what's necessary in every company, but primarily it should be the person who ultimately holds the purse strings. Costs get passed off within companies. General Counsel incurs a bill and perhaps passes it off to the business unit whose responsibility it was and forgets about it. Somebody somewhere higher up the tree ought to be able to survey the whole of those costs wherever they've ultimately fallen within the company and say, hang on guys, we're spending too much on this. Are there ways of aggregating budgets, for example, aggregating responsibilities to deal with it as a company problem rather than as a departmental problem?
That's a great answer, Chris. Jan, do you have anything to add to that?
No. I said most of what I wanted to say when we touched the topic.
All right, great. Well, Jan, this next question is for you, actually. Somebody wrote in. They said, most of your presentation focused on data disposition in large companies. And this person is wondering how some of these considerations change for companies that are still large but maybe small enough where they don't have full-time in-house legal counsel, and maybe their IT person might be their web developer. How does this change for them?
Yeah, that's a very good question. Well, what I think first, the most important when you what you need to start working on if you are thinking about defensible disposition is understanding the rules and regulations that apply to your company with respect to retention policies and the right to keep and the right to destroy. So, and that's something you can ask your accountant. You can ask I know that KPMG and PwC and Deloitte offer a lot of those services. You can also ask your external counsel. I know many external counsels helping companies to look at where they're operating, what departments they have, and they help them to create a filing plan. That's a small investment, but it's worth the investment because then you know exactly what you should do. Now, next step, once you know this, and one of the other things you can do is you can also look at some of our white papers where we've created filing plans for small organizations, and that we use as an example or a template, like this is at least what you should have in your filing plan, and this is the parts where you should look into or maybe ask for some legal counsel. Next thing is then when you want to start running these tools, it really doesn't take that much work. If you're considering bringing eDiscovery in-house because you're maybe subject to patent litigation or you expect other risks, this is something you can definitely teach or we can teach your IT department or your IT folks or somebody maybe in your financial department to regularly run these investigations and run these reports and then go to the business owners and ask them, okay, I found that you have all this data. How much of this is relevant? And then do this on an annual basis. Do this in January or whenever your business is slow. Make it a disciplined exercise, and you see that it's really not that much work. Actually, this is a very good question because we are doing this ourselves in our company. We don't have hundreds of thousands of employees, but it's all about discipline. It's all about discipline, and don't be sloppy and be proactive. And it's really not that much work. I think in our company, maybe it's 2 or 3 days a year that we really spend to these type of exercises. And believe me, it really helps cleaning up the data collections. Often 80 or 90% of what you find in certain file shares is duplicates or rubbish or all kind of other, I think you called it the usual junk, Chris or Mary.
Yep.
and get rid of it.
Okay, that's a great answer, Jan. Chris or Mary, anything else to add to that?
I just speak up for people. Jan has emphasized 3 things: technology, process, and skills. Skills rather than people. It's the people who matter as much as the technology, and it's easily overlooked. And the skills from eDiscovery are transferable into information governance and defensible deletion.
Yeah.
And I would just add that if you want to get really proactive, you address these things at the design phase or in the requirements phase prior to buying new technology. So So, for example, there's a company that I worked with that just now, as a standard operating procedure in any new database that they create, they have a flag for legal, and it's just there. And so if they need to pull database information, they can do it very easily. So there are things that you can do when defining requirements before systems are rolled out that will make all of this so much easier.
Okay, great. Well, unfortunately, we're out of time, but before we go, I want to point your attention to the complimentary white paper. It was authored by Chris Dale. If you just send an email to the email that you see on the screen, you get your free copy. Mary, Jan, and Chris, thank you all very